I'm Congressman Al Green's Chief of Staff. Unfortunately, the Congressman couldn't be at the event today because he is on a codel with Speaker Ryan in Houston for the hurricane. So he sends his best wishes for the panel, and just wanted to let you know that. Also, our office lost our Chief of Staff last year during ALC. And we just wanted to do a moment of silence for her. Her name was Jacqueline Ellis. So if we could just have a moment of silence, please. Thank you. Thank you so much. And I'll turn it over to Shantae.
Good afternoon. Thank you, Amina, so much for all of your help. We want to just thank the Congressman Al Green, for hosting this panel. We're really excited about this conversation. And we also want to acknowledge that Congressman Green has been a champion for the wrongfully convicted for some time, and we just support his efforts. I also wanted to just take a moment to acknowledge, as Amina mentioned, that Congressman Green's district was affected by the hurricane. And as we know, there's so many places in our world right now that are suffering from natural disasters. And so I just ask if everyone would just send love and light to all of those places, whether it's Mexico, Puerto Rico, Houston, Sierra Leone, Nigeria. Our planet, I think, is really in need of love and light. So I just ask everyone to just take a moment to do that before we get started. Thank you. And we also want to ask everyone to be interactive with this panel. If you're on social media, definitely tag and join in our conversation here. We're using the hashtag Innocence Denied, as well as the hashtag for the Congressional Black Caucus Foundation's legislative conference, which is CBCF ALC 17. So as you're tweeting and posting on Facebook and Instagram and Twitter, make sure you use both of those hashtags, Innocence Denied, and CBCF ALC 17. So a little bit about me before we get started, and about why I'm standing up here in front of you. I am the Special Counsel for New Initiatives from the Innocence Project. I joined the organization late November of last year. Before that, I was a public defender. I was a public defender in New Orleans, in Harlem, and in Brooklyn. And I, as a public defender, probably stood with, untold amounts of people to take guilty pleas. I thought about trying to count up how many people I had stood with to take a guilty plea, and then I sort of quickly decided not to do that because I didn't want to really depress myself any further. But I will tell you that in that first year in New Orleans, I probably handled between 400 and 500 cases. And what we know about our criminal justice system is that 95% or higher of criminal cases that come through the system end up in a guilty plea. And so we're at a crisis point, I think. I think there have been a lot of crisis points, but right now we're at this place where we have so many people who are pleading guilty to things in a very quick process. And the Innocence Project last year began to ask the question, why is it that we have so many innocent people pleading guilty to things that they didn't do? And we set out to explore that question with people in our group of 350 people we had exonerated through DNA exonerations, to ask the question, why was it that you pled guilty to something you didn't do, even though you knew that you were innocent? And so this panel is going to talk about the intersection between race, those guilty pleas, and bail. So what we've learned in the last year, as we've looked into this question, is that bail is a driver for guilty pleas. If a person is held in prior to a trial, prior to having that day in court, they're more likely to plead guilty to something they didn't do. So we're going to start our conversation with Rodney Roberts. And before we get to Rodney, I just want to give some brief introductions of our panelists. To my right is Rodney Roberts. You can clap. And Rodney is an exonerated person who spent 17 years wrongfully incarcerated for a crime that he didn't commit. Rodney pled guilty to this crime because of those pressures that we talked about. He's going to talk more about his experience, but because of those pressures to plea. Once he was released after DNA evidence showed that he was innocent, he has spent his time since March 2014 really championing this issue, right, of guilty pleas, of innocence. He's been working hard to bring change and reform to the system. Rodney Roberts. And next to Rodney is Tara Huffman. Welcome, Tara. Thank you. Get my papers together. Tara is at the Open Society Institute of Baltimore. She's the Director of Criminal and Juvenile Justice Programs. There, she has been working to bring attention to bail reform and also looking at harsh sentences. Prior to being at the Open Society Institute, Tara was also a staff attorney with the Public Justice Center and has worked as an advocate for national standards to reduce incarceration and criminalization. Welcome, Tara. Our next panelist is Adam Foss. Adam Foss, welcome, Adam. Adam is a former assistant district attorney with the Suffolk County District Attorney's Office in Boston. Since being a district attorney, he has founded an organization called Prosecutor Impact. And Adam is engaged in really advocating for a criminal justice system where the prosecutor has a different role than the one that we traditionally think about. Really thinking about how does the prosecutor reinvent themselves to fight for justice and not just fight for convictions. Recently, Adam was recognized by the Mandela Foundation as a 2017 Nelson Mandela Changemaker of the Year. Welcome, Adam. And our final panelist is Professor Kristen Henning. She's a professor at the Georgetown School of Law. She's the director of the Juvenile Justice Center there. Before joining the faculty, she was an attorney with the Public Defender Service here in DC, where she represented juvenile people who are charged with crimes. Once leaving the Public Defender Service, she came to Georgetown in 2001. As the professor for the Juvenile Justice Center there at Georgetown, she's not only charged with representing juveniles in court, but also training next generation of public defenders and advocates for youth. Welcome, Professor Henning. So I want to bring it back to Rodney now. Talk to us about your experience. You, as I noted at the beginning, you pled guilty to a crime that you didn't commit. Talk to us about why that happened.
Well, when I was arrested and brought into custody, while I was there, I made the pressure itself was overwhelming. The fear of being incarcerated, the fear that I was in custody for something I didn't do, despite my multiple claims of innocence, no one would listen, no one would believe me. Being placed in a cell, being processed, fingerprint, the whole experience itself was overwhelming. When they told me that, I was there for the charges I was brought in, which were at sexual-related offenses, I was completely taken by surprise. So one, I fought for my innocence, and two, it's just a crime that I'm incapable of committing. And I tried to explain that to everyone, and their response to me was the same response that they hear from every defendant. Everyone says that they're innocent. So being in custody, and for the first time in that nature, I was afraid. I was disconnected from my family. I was isolated. They had already proven to me that they could hold me in custody, so their threats of holding me were fulfilled by the fact that I was being held. While in custody, my attorney came to me. Let's bear in mind, to be brief with it, I had 3 different public defenders within a 5-month period. The first public defender who came to interview me, I explained to him I'm innocent, help me. So he said, well, listen, this is what I'm gonna do. I asked him, could he please get the police reports? He did what he could at that point. The next time I went to court, there was a different public defender. I asked him, where'd the other guy go? He said, I don't know this guy. I'm here to help you today. And his position was, I'm just here to make sure that you get in court and you enter your plea. At that point, I was so frustrated with the situation that I refused to go in the courtroom. I wasn't going to dignify the charges or the offenses in any shape, form, or fashion. So the judge, in all his wisdom, decided to arraign me with the door open while I was in the bullpen, which was the holding area. There's a door to separate the courtroom and the bullpen. I'm holding on to the bars while they're holding court while I'm locked inside my cell, which was crazy within itself. I thought by taking the stance of not going to courtroom, I was going to definitely elevate myself above and prove that I was innocent. That they just figured out a way to get around that. The third public defender who came to me, at this point, I was so, and my family was so shocked at what was going on and so unprepared, especially financially. We had any money to help. We couldn't afford a private attorney. No one knew law at that point. And so by the time the third attorney came, the public defender, it was the public defender who actually convinced me that it was in my best interest to plead guilty. At this point, I had never even met either prosecutor. The public defender brought me in the fabricated story that there was a witness waiting outside right now to testify against me, and that I would spend the rest of my life in prison if I don't take this guilty plea. And the prosecutor was prepared to start trial instantly. And I'm listening to all this, like, how is that possible when I'm innocent? And he's saying, well, listen, no one really cares or believes you when you says that. This is the evidence they have against you. And it was a public defender who really laid on, because in my mind, this person was here to help me. This is the person that's here to help me get out of this. But at this point, this person was there telling me these things. So it wasn't, at that point, I was totally afraid. I was afraid for my life. I just wanted my life back. I had my son who I had custody of. I just wanted to get back home. My mom's, I didn't want to be here for the rest of my life. So what really convinced me and really pushed me over the point where to plead guilty, even though I know I was innocent, I'm trying to tell them, and they really didn't. And I'm saying, listen, I'm feeling so bad for myself. Even the thought of pleading guilty to a crime I didn't commit, I felt like I was sabotaging myself. I felt like I was just selling myself out down the drain. But at the same time, I felt like I was saving myself, because how could I, if I go to trial, I would never get out. So when they took me in front of the judge, it was the judge who actually put what I would always say, the nail in the coffin with pressure, to make me think that pleading guilty, even though I was innocent, was the best thing to do. Because the judge said to me, if you go to trial and you get found guilty, I'm going to have to sentence you to the highest level range of sentencing, which for these crimes may be 25 to life, young man. If you take this plea, you'll be home in 2 years. So in my mind, 25 versus 2, I looked at Sesame Street, hey, 2 is a much more number. So I'm like, I take this 2 years, I come home and I go down, do whatever they send me, and I'll do what I can do, and I'll be home back with my family, and I'll fight it then. But, so when I came, I said, okay. I cried, because it felt so bad. I felt like I was just doing myself in, but I had to do it. So I went in, I pled guilty to the crime. They didn't really, at that point, once they had convinced me and made me feel like, I was doing the right thing, that's when they loosened up on me. They didn't ask me no serious questions. Did you do this? Yes. Did you do this? Yes. Did you do this? No. It was never no real intricate details. So they said, okay, we're going to dismiss, because the charges was kidnap and sexual assault. So they told me, we're going to dismiss the sexual assault. We're going to downgrade the kidnap to second degree, which you'll do. It'll be 7 years, and you'll do 2 years, and you'll come home. we're going to put on the record that no one got hurt. And that, for me, was to really convince me that at least I wouldn't be in prison for saying I hurt somebody. So that's how I was able trying to rationalize, grasping for straws for things to make sense of what I was doing. Well, at least I won't be there for hurting anyone. And, all right, at least I'll be home 2 years. However, when I was sent to prison, once I went in front of classification and parole, they told me that the records reflected that I was there for a sexual assault. And I said, well, hey, I thought that was dismissed. I didn't plead guilty to that. But because the record said that, they processed me that way. So every time I went to parole, I was denied access to certain parts of denied opportunities for halfway house, reduced custody. I had to do the full term. And I served the full term. Parole denied me multiple times. 4 times I was denied by parole because I would not say I was guilty to the offense. I said, listen, I thought that, I said, actually, I didn't do any of it, especially that part. So I went through the process. I served the full 7 years in state prison. When I went to parole classes, I did everything. I studied law the whole time there. Only job I would work was a law library. That was it. If you wasn't gonna put me in a law library, I wasn't doing anything. So they put me in the kitchen, I refused to go. They put me in the mop floors, I refused to mop the floors. So they put me in a law library eventually as a clerk, and that's when it all began for me. I was able to study. I was able to be around individuals who were also laymen, but they were very versed in law. So they helped me develop understanding of jurisprudence. In time, I grew. I was able to help other prisoners myself. But after the 7 years, when I thought I was being released, on the day of my release, and this is what distinguishes my situation so much, on the day I was being released, I had my family waiting for me outside. Everyone we was all ready to go. I was ready to go. And they had, unbeknown to myself, New Jersey, which I'm from New Jersey, I'm from Newark, New Jersey, had passed a law called the Sexual Violent Predator Act. And under this act, if anyone had been convicted of a sexual-related offense, you were going to be civilly committed. And because I wouldn't admit guilt to the offense, automatically they determined that I was dangerous because I wouldn't admit guilt to a crime I didn't do. So they civilly committed me. And in the civil commitment process, the same as civil commitment that you would see when someone is insane, and this is like a hybrid. It's a combination between the Department of Human Services and the Department of Corrections. So I was brought there to be given treatment, sexual treatment, and held in custody. I stayed there 10 years. 10 years, and because I could not move forward in treatment because I would not say I was guilty, so I could not be treated. And it came to me multiple times, Mr. Robert, just say you're guilty, and I could not do that. I already so felt like I had betrayed myself once, and I was not going to do that again. I could not live with that again because it took me years to get over that feeling, to rebuild myself from that. So I was not going to do that again. So I sat for 10 years in the civil commitment facility and surrounded, it was one of the most horrible experiences I ever survived in my life, and experienced in my life. Just the environment alone was horrible. I can't begin to tell you the atrocities and the social and the mental and emotional things I had to survive just to make it through that. I thank God that I came home with my sanity intact, that I'm able to sit in front of you to speak about it. So, as a result of going to being civilly committed and standing, I was assigned an attorney whose name was Mr. John Dewar, who to this day I give him his utmost. He's a public defender. So he sat me down. I said, listen, man, this is what the truth. This is what happened. I pled guilty to a crime I didn't commit. I should not. So he believed me. He said, I'm going to take a chance with you. He went and he found, now mind you, the public defender told me that the victim seen my photo, and when she seen my photo, she started crying uncontrollably, and that she was out ready to, right in the courtroom, ready to identify me. Now, John Dewar went, and his investigator, and found the victim. Went and brought my photo to her. This is Mr. Roberts. She seen my photo. She said, I don't know who that is. They said, you identify. She said, I never identify anyone. In fact, she didn't even know anyone had been arrested for the offense. And all this time they had me convinced that this lady had. She said, I don't know who that is. That's not the guy. So in her heart and mind, so they said, well, you give a statement to that. Her position was, yes, I give a statement because you got the wrong guys. I mean, the guy who did it is still out here running around. You need to put your focus on who did this to me. That's not him. So she became a champion for me as well. She would show up in court. Myself, once I found out, I filed a post-conviction relief, pro se. I was granted a hearing. The judge in my case, Judge Cody, I filed multiple motions to him trying to get back in front of him. But finally, I was able to get in front of him. And even despite her giving a statement and her saying, I'm not the guy, he refused to acknowledge that he made a mistake. Now, I've come to learn that if you find a judge that say they made a mistake, you found like something that don't exist, like a unicorn, some mythical that don't really happen, because judges just don't say they make mistakes. So as opposed to saying he did wrong, he denied me. So I filed pro se appeal to the appellate division. Appellate division reversed, granted me a full hearing. This time they brought the young lady in, they brought the attorney in, and they brought the prosecutor, they brought the officer who wrote the police reports, because they want to know how did this happen. So the young lady, she got on the stand, they asked her, she said, that's not him. She said, I don't see him. And the prosecutor's like, what do you mean? She said, that's not him. Y'all need to stop, waste your time. I don't know who that is. Again, and the lawyer took the stand and said, well, listen, I had that morning maybe 45 clients in the bullpen alone waiting to be interviewed. He had a caseload of 60 that he had to see in just that morning, in that afternoon. So you had a caseload of 60. I'm like an assembly. I'm like, okay, next, okay. So he admitted that he had such a heavy caseload that he was just in assembly mode. And, of course, the detective, he just stood on his ground. And, she came down, even though she's saying she never did. Well, I'm telling you. So they asked him, where's the photo she signed? We lost it. Okay, we can't find it. Now, not on top of that, all the DNA evidence that the state claimed that they had against me suddenly disappeared. We asked for it for 9 years now. The evidence was claimed it was lost. For 9 years, we said, we can't find it. They sent an investigator after investigator claiming to look for it, and it was, we can't find it. So I appealed to the appellate division a third time, because I reversed third time. The appellate division was kind of, at this point, frustrated with the situation. So what they did was they assigned me a new attorney and a new judge. So when I was assigned a new judge, Sherry Hutch Henderson, and a new attorney, Michael Pasicaldi, who asked that they search again for the DNA evidence that we've been looking for 9 years plus. And now all of a sudden, it mysteriously pops up. Oh, we found it. It was mislabeled. Well, that's the same place you looked before. It wasn't there before, and so now, 9 years, this evidence that mysteriously gone is here now. Now, I was in mixed emotions. I was mad on one side of me, but I was happy on the other side. So I was walking around, hey, I can't stand him on the other side. Thank you. So I was just going through so much in my mind, trying to get. So I was moving forward with that, and so the DNA was sent to the state lab, and it was tested. And as a result, they brought me to court when I was exonerated. My guilty plea was vacated, and but at that point, even though my guilty plea was vacated, I still wasn't released from custody because I was civilly committed. So I had to be sent back to the civil commitment facility to have a hearing for them to determine my status for release. So when I went back after that, I felt invincible at that point. So I said, well, they said, well, the attorney they assigned to me, she said, well, it's going to take me 2 weeks to do the motion to get you back in court. I don't know, for some reason I kept hearing this song back in my head, like the Beyonce song, you just don't know about me. I kept hearing that song. So I got my side right. So I filed a pro se motion to the court and took directly to the judge. And so within like 3-4 days, I got a response saying that he was going to give me a hearing within 3 days. So within 3 days, I was in front of, and she was looking at me like, wow. So I went in front of the judge, and he was saying, I can't let you go until they dismissed the charges in the state court. Because once your conviction is vacated, then the charges still exist. They just got to determine, the prosecutor, if he's going to dismiss the charges. So he said you go to this. So I went back, and that song played again. You just don't know about me. So I did a pro se motion to dismiss for speedy trial and dismiss the charges, and it was granted. It went right back to the same judge who just vacated my conviction. So once I did that and the all paperwork was transferred back and forth, I called back to the courtroom judge for civil commitment, called me back. He said, I'll have you out of here in 2 days. They called me that next day when they called me. So when they called me, my family was like, yeah, we're going to take pictures when you come out. I was like, listen, you ain't going to do none of that. You don't even turn that car off. You just roll that window down. And when they come, I'm just gonna dive in, right? And when we get down the street, we're gonna celebrate when we get down the street. So, and that's what we did. When they came, they was like, come on, every people was out there waiting and saying, hey, bye, Mr. Roberts, there, whatever. I threw my stuff, we jumped in the car. So we waited till we got down the road, and we jumped out. Everybody thought we was crazy. We was all on the street, side of the street. Yeah, it's all right. And so since then, coming home, and a number of things have happened. One of the issues that I have regarding when you are released from exoneration, although you're completely cleared and innocent, you have no state at this point, through research, has an agency designed to help an exoneree readjust back into the community, like with housing, or employment, with counseling, and family services. It just don't exist. So because maybe they just don't think they would make a mistake like this, so they don't delegate monies or resources to help the exonerees. So I had to struggle hard. I came home with really no money. I was unable to be given the compensation from the state because I had pled guilty to the crime. In New Jersey, if you pled guilty to the crime, you get no state help from the state. So I was left without any help, without any resources for employment. I had to compete with my counterparts at that point was guys on parole and probation. And the guys on parole and probation were getting hired before me. Jobs were saying, well, look, we'd rather hire them because we get tax deductions because they're on parole and we get these big exemptions. And although you're a great guy in your story, but we're here to make money. So employment was an issue for me. So I struggled hard to maintain. It was great. Lucky for me, I have a great support system. Thank God that I have my mom, starting from my mom, who's a matriarch, on down to my support. So I had and that helped me carve out a path for myself. And that path has been to bring greater awareness to wrongful convictions, to try to shine some light on how it can happen to anyone. How you see, statistics show how African Americans, we are at risk even higher to anyone of being arrested and forced to either plead guilty to a crime we get or plead guilty within itself. So that became my passion. I let my passion lead me, my feeling that a need to help lead me, and that led me to some positive paths of people, which the Innocence Project embraced me. And in their embracing me, that helped me to shape and format my concept of how I wanted to help and what I wanted to do with what happened to me, because I didn't want to come home and be angry and bitter and I didn't have that in me. I left all that in that cell. When they called my name to leave, I left all that in there. I almost broke my leg trying to get out of there. But all that's there. So when I came home, I came with a different mindset, and people embraced me because of that. So I was able to develop an income. I was able to find a law firm to help me fight for my compensation in federal courts. And then my federal case took off because of what happened, the state and the civil commitment. I won so many motions back to back that I was able to develop an income for myself to help me and my family. And although that put me in a position where I was able to move forward, it still didn't erase all the trauma that and the injustice that not only I experienced, but so many others experienced. You know, so that's my story. You know, I'm here, and I'm here today to bring some awareness and bring forth how plea agreements. Most people, the book says one thing, but when you're in that situation and they are coming at you, and you will feel like you have nothing, you feel like I have to do it. It hurts. It hurts really bad. It really does, and it's a scar that you have to grow. But it hurts even worse to think that I'm gonna be here for the rest of my life for something I didn't do. So, so it's such a horrible experience, such a fearful experience. But that's what I'm saying. Thank you.
Thank you so much, Rodney, for sharing your story. I mean, there are several places where we can see your innocence was denied, right? From the defense attorneys you met, to the prosecutor who offered you this deal, to the judge who you said pressured you to plead. A lot of places along the way, you were, I think, denied. What we think about is this presumption of innocence, right? That everybody who comes through the system has that presumption of innocence. But what we see is that there's a presumption of guilt in a lot of places, especially for people of color. We don't get that benefit. Yeah. And I think a lot of that has to do with the history of this country. But I want to focus us in on one place, because as Rodney so beautifully talked about his journey, there are a lot of places where those roadblocks were put up. But the bail setting place, right after you're arrested and you're brought before a judge, and that judge has to determine whether or not you're going to stay in jail or go home, that's where you should really enjoy the presumption of innocence. You should be presumed innocent. So often we see that not happening. So I want to ask you, Tara, to talk about the impact of bail on people's decisions to plead guilty. What is bail? How does it work?
Sure. Good afternoon, everyone. Good afternoon. And thank you so much for joining us here. So unless you've interacted with the pretrial justice system in your jurisdiction, your understanding of how bail works is probably informed by television. And so let me try to spend just a few moments just explaining exactly what bail is and how bail works. And so when you are arrested for an offense, you're taken into custody and you're booked into the local jail, whether it's a city jail or a county detention center. And at that time, the decision is made about whether you go home or whether you stay. And a commissioner or a judge is the one who makes that decision. And so they can decide based on the charges, based on you, based on any criminal history you may or may not have, and then of course based on a whole number of other factors that are playing in the background that we call structural racism. They can determine that they're going to release you on your own recognizance, which means they basically let you go home, no conditions of release. They just tell you that they're going to inform you of when your next court date is, and they trust that you're going to show up for that court date. They can release you with conditions. They can say, okay, we're going to let you go home, but you're not allowed to drive, or you have a 9 p.m. curfew, or you have to be subjected to drug treatment, or they can put a whole bunch of conditions on you in terms of your release. So you're home, but you have to meet all of these other conditions, and the purpose of these conditions is supposed to make sure you stay out of trouble and make sure you show up for court. Or they can determine, you know what, I don't know if I can trust you to come back. So what I'm going to do is I'm going to set a bail. In other words, I'm going to make you put up money that says, I'm gonna give you money. If I show up for court, I get the money back. If I don't show up for court, then I lose the money. And that can happen in a secured sense, which means that you're basically working with an insurance company that they call a bail bondsman, who puts up the money for you. They're the ones who are actually putting up the money and betting on the fact that you're gonna come back. Or they can do it in an unsecured way, which is it's a promise to pay. So we're gonna give you a $5,000 bail. No money is exchanging hands. As long as you show up for court the way you're supposed to, you don't have to pay the $5,000. The final decision they can make is to say, we don't trust you to come back, and we think you're a danger to the community, so we're not even gonna set bail at all, we're just gonna hold you, and that's called being held without bail. So those are all the different decision points that a judge or a judicial officer can make once you've been arrested to make the decision whether you do or don't come home. Now, according to...
Can I just interrupt you right there too? Because one thing that I want to make clear is like, Tara said judge or commissioner. Commissioner sounds super fancy.
Go ahead.
I've met many bail commissioners that don't have a legal degree,
Nope, not required.
that have not worked in the court system. They're a person who ran for position and got it, and they make money by going and doing this transaction. So don't think that somehow these people have legal training to say, okay, you go home and you don't.
In Maryland, for instance, you're not required to be an attorney. You don't even run. You're appointed. It's a job you apply to. So they're considered an officer of the court. So under U.S. Supreme Court law, there is supposed to be a presumption of release that accompanies the presumption of innocence, which means the presumption is if you've been arrested, you're presumed to be able to go home unless the state can make the argument that for whatever reason you should not go home, or there should be some sort of bail or other conditions set on your release. But the way it works in far too many jurisdictions across the nation is that presumption gets flipped on its head. And instead of there being a presumption of release, there's a presumption of detained. And instead of the burden of proof being on the state to prove that you shouldn't go home, the burden is on you to prove that you should. And so it has become a perversion of the system, and it's been going around for so long and been operating in this way for so long that people just sort of take it for granted. But to tie it directly into Rodney's story, if I'm that person who I don't get to go home, I'm not the release on recognizance person, I'm not the release with conditions person, I'm the one who's gonna have some sort of bail set. Let's say that you set my bail at $50,000. That's the amount that has to be paid. Somebody has to pay or put up $50,000 for you to go home. Now, most of us, how many of y'all got $50,000 just sort of lying around? Nobody? Oh, come on, y'all. Come on, financial wealth. Come on, wealth building. So $50,000, nobody has $50,000. And so what the insurance companies have done, if they have figured out a way to profit on this. And so what they do is they set up an intermediary, and this intermediary is called a bail bondsman. And what you do is you go to the bail bondsman. The bail bondsman has access to $50,000 because of the insurance company. That ain't his or her money either, by the way. That is not the bail bondsman money. That money belongs to an insurance company. But you can go to the bail bondsman and you can say, put up the $50,000, and you don't have to put up the $50,000. The bail bondsman will put it up for you in return for a fee. Just like you pay a premium to your car insurance company, you're paying a premium to the bail bondsman. And just like you don't get that money back if you never have an accident, once you put up that money to the bail bondsman, you don't get that money back even if the charges are dismissed, even if you go to trial and you're found not guilty. You never see that money again. And the court will accept 10%. So bail is set at 50, the court will accept 10%, which is 5,000. And so the bail bondsman will say, okay, you give me 10% of the 10%. You give me 500, and I'll put up the 5,000, which will then secure the 50,000 if you don't show up for court again. And some bail bondsmen are really nice. They'll even go as low as 1%. But regardless of how much it is you have to put up to the bail bondsman, you never get that money back. And so if, again, I can get access to a bail bondsman, me or my family are having to come up out of pocket and pay money that's not going to rent, not going to car insurance, not going to groceries, not going to utilities. Oh, and by the way, I ain't been found guilty of nothing yet. It's an arrest, it's a charge, it's an accusation, but I'm already coming out of my pocket, and there's already an economic impact on me simply because somebody has accused me of doing something. All of this happens before there's a determination of guilt or innocence. All of this happens before there's even a determination of whether or not the charges are even valid. Because that's the prosecutor's job, and we haven't got to the prosecutor yet. All of these decisions are happening before you even get to the prosecutor. So all of this is going on, and so again, if I can get access to the bail bondsman, I can get the money up, there's still gonna be some sort of negative economic impact to me that I have to figure out how to recover from. But let's say that they set my bail at $5,000. $5,000, 10% of $5,000 is $500. But let's say I don't have $500. You all probably are well versed enough to know that there are a number of people, particularly in urban areas or even in rural areas, who live below the poverty level. $500 might as well be $50,000 to individuals. Because, you know, don't raise your hand on this one, but how many of you just got $500 just sort of lying around in the event you get arrested for something and you need to post bail for yourself? So there are, according to research, that's been done nationally, and again, this is something that's becoming more of a national issue, drawing national attention and getting research. In Philadelphia and Miami-Dade County, for instance, they did a study, and they found that only 50% of defendants were able to post bail when it was set at $5,000 or less. That means that half the people who had a bail of only $5,000 sat in jail because they could not come up with $500, which was the amount that they would have needed to actually get themselves out of jail.
And just to note, Tara, nationally, at any given night, 700,000 people are incarcerated in our local jails in this country, and 3 out of 5 of those people cannot afford, are pre-trial, right, are waiting to get to a determination about, you know, where their case is gonna go. They're there, they should be presumed innocent, but they're still there because they can't afford bail.
Think about it this way. I just want to pick up on what you said. Slavery, when we learn about slavery, everybody says 400 years, 11 million people were enslaved. That's like the numbers that people have. Last year, 12 million people went through our jails in a year. 95% of those people left without a committed sentence. So we are paying to warehouse people for an average length of 23 days apiece, but people sit in jail for 18 months, 2 years, all the time.
All the time. So over the past 20 years, the proportion of felony defendants released with no conditions, which means the number of people who are not getting to go home is increasing. Whereas the amount of money that people are being forced to pay in order to go home is also increasing. And so the system is getting more disadvantaged, particularly towards people and people of color, poor people and people of color, than it is actually advantaging people and giving them their presumption of release and their presumption of innocence. Right?
I just wanted to add on to, you spoke about the number of slavery. From my research, under the 13th Amendment, which is the abolishment of slavery, it says slavery, no involuntary servitude shall be permissible in this country except when you're duly convicted of a crime. So once you're incarcerated, you find yourself duly convicted as a result of a plea agreement or trial, you're reduced to the status of a slave, and you're considered disenfranchised. All your rights are restricted. You have no right to vote. You have no right to gainful employment. So you'll find that became a new form of slavery in this country, and it impacts African Americans, but it impacts us, everyone, black, white, candy stripe at this point now.
Yeah.
And again, if I'm that individual who's sitting in jail because I can't afford to post bail, that pressure to plead is building on me every single day. Because I'm making phone calls, I'm like, Mom, I need you to get this together. Sis, can you do this? You calling your cousin, you calling everybody you can think of, and they calling everybody they can think of to try to get the money up. But while all of that is happening, days are ticking by. And jail is deliberately not a pleasant place to be.
Absolutely not.
And so every single hour that you're sitting in that jail cell, and if you are in the unfortunate position of having a public defender who's putting pressure on you, having a prosecutor who's just trying to get through the case. Oh, by the way, approximately 90% of the cases in our country, and I think you said this, in 90% of cases in our country, people plead guilty. So 90% of the people who were convicted of anything pled guilty to it. Only about 10% of cases are actually going to trial. And that's because the pressure to plead is heavy. And unfortunately, it comes from both sides of the system, including the folks who are supposed to be helping you. Now, I know Kristen is working on that. She's doing her thing, and we're going to let her talk about the wonderful reform she's got going in place, but it can be very heavy. And so you sort of ask the question, why would someone ever plead guilty to something that they didn't do? It's because the pressure is there. You're sitting in a hellhole. You're separated from your family, and you can't see your way out of here.
Your life's falling apart.
Your life is, if you are one of the primary income owners, or you contribute to the household income, the rent's not getting paid. You're not earning money. You lost your job. And plus you got an arrest record now. Even though it's not a conviction record, it's still an arrest record, and there's still a number of employers, they don't even bother to see if it says not guilty, they just see the charge. And they will deny you. And to Adam's point, because of the way the system works, you're looking at months and maybe even years of sitting there while your case works its way through the system. All of that can build up on someone and say, you know what, 2 years is better than 25. 6 months is better than 6 years. Time served if I've been there for a few months. You're like, wait, I can go home today if I plead guilty to that? I'm going home today because my freedom can sometimes trump my innocence. And I'll trade if it means I get to go home. So I just want to pick on Maryland for a minute before I turn it over to the next speaker. And I can pick on Maryland because I live in Maryland. So our Office of the Public Defender did what I call a groundbreaking report on bail and the way bail works in our state. We've known for quite some time that the bail bonds industry is just a party that should not be part of our criminal justice system, and that there were a lot of money being made on the backs of people who were trying to maintain their safety, even as they protested their innocence. But what Maryland found is that, let's see, over a 5-year period, no fewer than 46,000 defendants were detained on bail for more than 5 days at the start of their criminal case. And of these, more than 17,000 were detained on bail amounts of less than 5,000. And for those who did access the bail industry, Maryland communities between 2011 and 2015 were charged more than $256 million in non-refundable corporate bail bond premiums. Let me say that again, $256 million within a 5-year period. More than 75 million of those premiums were charged in cases that were resolved without any finding of wrongdoing. Let's talk about the racial disparities. The mean bail for black defendants is 45% higher than the mean bail set for white defendants at the initial appearance. And
did y'all hear that? Did y'all hear that? There's a lot of things going on. Can you just say that one part again?
The mean bail, the average bail amount for black defendants is 45% higher than the average bail amount for similarly situated white defendants at the initial hearing.
Let that sink in for a second.
The bail system, it has a disproportionate impact. Over 5 years, black defendants, and again, I'm still talking about Maryland, were charged premiums that amounted to $181 million, while defendants of all other races combined were charged $75 million. And they broke this out jurisdiction by jurisdiction in Maryland, and they found that of all the 24 jurisdictions in Maryland, Baltimore City, if I could show you the graph, I should have brought the thing so you could show you the graph. I can tell you that Baltimore City's bar looks like this. The next bar is way down here in terms of how much where's the money coming from? Which communities are paying the most towards the bail bond industry? And so Baltimore City's bar looks like this. The next one, which is Prince George's County, looks like this. And then it goes down from there. Also, we can identify 3 communities in Baltimore City alone who in the entire state paid more than 20% of that $256 million that happened between 2011 and 2015. So this is something that is ravaging poor communities and communities of color. And one of the many negative impacts that it's having is that it is causing people to plead guilty to offenses that they're not guilty of, as opposed to exercising their constitutional right to confront their accuser and make the state meet its burden of proving me guilty.
And I just want to sort of put a pin, like underscore that as Adam did. So when we talk about, again, going back to our theme for today, which is innocence denied, not only is it on an individual level, but community-wide, right? This whole community are being assumed to be guilty when they come into contact with the criminal justice system. They're coming into contact more frequently, and then in order to get out on bail, they're paying so much more, 45% more to get out from resources that they really don't have. So if you're not getting angry, you know, you might not be listening, but just this idea that not only are individuals not given the presumption of innocence, but whole communities. So we're going to take it now to Adam to talk about, you know, some people say that the prosecutor, a lot of conversation now, the prosecutor is probably the person in the system that has the most power. So I want to hear from you, Adam, about what role do prosecutors play in this bail process, and particularly the role of racial bias in the exercise of prosecutorial discretion as it relates to setting bail or requesting bail amounts. I shouldn't say you said it.
All right, so let me just like level a few things up. First of all, young people, how y'all doing? Good?
Yes, welcome.
There's no probably about it. The prosecutor is the most powerful person in the criminal justice system. Period, fact, end of story. While I'm thankful to be here on behalf of the Innocence Project, not on behalf of, but because of the Innocence Project, and while I will apologize for what happened to Rodney on behalf of the system, I'm not going to talk about innocent people going to jail in the case of Rodney, because there are lots and lots of guilty people who are in jail who are no less innocent than someone who didn't commit a crime at all because they come from communities that they were born into. That is community innocence. And so the Innocence Project does great work, and there's hundreds and hundreds of people that they rescue, and hundreds and thousands of others that they need to. But we are talking about millions and millions of lives that are going through a criminal justice system every year and sitting in jail. Our largest mental health facilities are our jails: Cook County Jail, Rikers Island, and LA County Jail. That means a prosecutor stood in a courtroom and saw a person with a serious mental health issue and said, the best thing that I can do for the community is put you in jail right now. That means prosecutors stood in a courtroom and said, you have committed a crime. I don't want you to commit a crime again, so what am I going to do? I'm going to take you out of the community, increasing the likelihood that you lose your job, lose your housing, lose any sort of educational opportunities that you had or maybe that you were pursuing, and put you in a place where trauma is the only way that you survive. You don't learn how to be a kind, gentle, nonviolent, educated person in prison or in jail. You learn how to survive. And most of the people that go into jail, we're not talking jail right now because of bail, but most of the people who are going in there are coming out. They're not doing what Rodney did. What Rodney did was the extreme example of our criminal justice system. And what happened to Rodney, there's a special place in hell for people who stood by and watched that happen. What I want to tell you is, in my experience, the people who go to work every day in the criminal justice system on both sides are ultimately good people. They go do public service work because they want to help, not because they enjoy this legacy of mass incarceration, not because they enjoy destroying communities and families, not because they enjoy locking up African Americans in disproportionate numbers. what happens is they walk into this system that was created not in Charlottesville, not during the Civil Rights Movement, not in 2016, not in 2008, not even at the beginning of this country. The concept of bail, the first place that you see bail in our history is in the Magna Carta. Does anyone in here know when the Magna Carta was signed? 1215. Our criminal justice system is laid out in the Magna Carta, particularly the role of the prosecutor. And unlike all these other industries where we're making billions and billions and billions of dollars by advancing and keeping up with the times, technology and information and data, the criminal justice system remains virtually untouched since the signing of the Magna Carta. Imagine if you went to your doctor and you went in to get an operation and they were like, bro, the operation manual I have on how to do this heart transplant is from 1215, so lay down. I'm gonna just take out my axe and this stone tool, we're gonna get it done. We're laughing because of how ridiculous that is. And the reason that that isn't a reality is because everyone has to go to the doctor. Everyone has to get medical treatment. And by everyone, I mean white people. The reason that the criminal justice system has been allowed to operate in this way for so long is of who it impacts. That's why if you see me, I'm a little bit upset right now, is because there's empty chairs in here. There's no bigger issue affecting our people than the criminal justice system. And so the fact that we didn't have just a whole day just on bail, and that there are empty chairs in this room tells me that the problem isn't just white people. The problem is us not taking advantage of opportunities like this to learn actually how easy of a fix it is. Rodney's case is extreme. I don't want you leaving here thinking that is the kind of evil that we have to fight against. Tara.
It is.
Yeah, I'll say more about that, because that's
Yeah.
one place I'm going to push back on.
Okay.
Yeah.
Tara talked about the amount of money that's going through the criminal justice system. That is not trickling back to prosecutors. Despite what you've heard, despite what you've read, please believe me when I tell you that money is not going to prosecutors for putting people in jail from some bail bonds industry that's making, how much did you say?
Well, in Maryland alone, $256 million over 5 years.
$256 million over 5 years. The bail bonds industry is their own private thing. And imagine if we just took them out, what we could do with that money. So if the money, if it's not financial, if it's not evil, like the people that we're treating in Rodney's case, then what is the incentive? Fear and tradition. When I was a prosecutor, the biggest thing that we were worried about was that person going out and do something the next day. That was it. I asked for bail because I was afraid that if I did not, and this person left and killed someone, I would lose my job and I'd be in the newspaper.
But does the data support that?
Not even close. Not even close. But it's there. The fear is there. You have really, really young people coming out of law school making these really, really impactful decisions. Very rarely do you have a senior prosecutor doing the arraignments. It's almost always the junior, lowest level prosecutors who actually are in the best place to change their mindset about doing their job. Because they come in and they're thinking, I'm going to do something, I'm going to save somebody. And yet, they instill this fear in us that if you screw up, it's going to be bad for you. Despite the fact that the data is completely the opposite. How many of you feel safer in your car than you do in an airplane? Really? Really? Let's be real. The data is completely on the other side. You're way more likely to get hurt in your car than an airplane. But the fear that drives what happens when a plane crash happens makes us crazy. And that's what's happening to prosecutors. All right? Listen, that, That's a choice. That's a choice. You are overwhelmed with work because you do not see the human beings on the other side. It's not an issue of work. It's an issue of empathy. And the reason that there's such an empathy gap is that the people who come to the prosecution office come from nice law schools, who went to a nice college, who grew up in a nice high school, in a nice neighborhood. I worked alongside people that had never interacted with a person of color before. And so when a young person came in who had just robbed a store, that prosecutor, not because they're a bad person, but because they just weren't exposed to anything but privilege, looks at that person and sees them as an act.
But also as a prosecutor, doesn't that privilege continue because the prosecutor has complete immunity and really very minimal oversight? I was saying.
Yeah, Rodney just noted that the prosecutor has usually complete immunity and also lack of oversight.
Right. I mean, so that privilege that they enjoy coming up continues even in the office.
Correct.
They have no one to monitor them in that way.
Correct. Which is, again, not an issue of the character of prosecutors. It's an issue of we have to care more about the people that are here. We're not sitting there thinking, even if I screw up, nothing's going to happen to me. We're actually thinking the opposite. If I screw up in the wrong way, something's going to happen to me. That's what we're told. We're not trained the opposite. If you screw up, if you ask for the wrong bail, innocent people might go to jail. I never heard that in training or in law school. It's an issue of education. It's an issue of training. It's an issue of creating a pipeline so that more people look like us and more people come from the backgrounds that we come from that are in that office. You can't really teach a lot of empathy. Pedro. Oh, hell yeah. It's not, so I don't want to say this defensively. I want to say this as informative of like our actual power to do something about it. It's not corruption. It's not money. It's not bad blood. It's not bad people. It is the idea that Pedro Hernandez, if he gets out and kills someone, the media is going to be all over people. That's it. The media was the media helpful, or was it social media that was helpful?
Because of the journalist and one of many journalists that covered his story, because he was innocent. And later on, it was corruption because the officer that arrested him was also fired. Because
Officer.
I'm not sure if he was fired, but you know, there was a lot of internal stuff going on with that department and with that police officer. I'm just saying, so incidents like that, there is. I'm not saying that the DA office itself, but there is a lot of disconnect. So.
For sure. And I'm not trying to pass the buck. Another thing that we don't do very well in prosecutors' offices is teach young prosecutors that the police are not our teammates. I remember very clearly being told, these are your teammates. And if you screwed up on a case, if something bad happened, guess what the first thing the police did to you? But you're not behind that thin blue line. But as young people, we come out of law school having never faced any adversity at all, having never even been to the communities we're prosecuting in. And we see cops and we're like, ooh, the gang unit. Ours is called the Youth Violence Strike Force. And we're hanging out with them as young people. We're just like, oh, hell yeah, I'm with that Youth Violence Strike Force. That's like just like adolescent mindset, just trying to be cool. There are problems everywhere. But I do not want to disenfranchise the people in this room for taking control of that power, because when next year comes around and Darcel has to run for district attorney, guess what he's going to be answering a lot of questions about? Pedro. But you see what's happening in Chicago, in Tampa, in Milwaukee, lots and lots and lots of cities are electing progressive prosecutors because they understand that this bail system isn't working. It's not working. We're locking up lots of people that don't need to be in there. They're going home, and they're actually worse off. We're not doing our jobs properly. And at the end of the day, what I want to feel as a prosecutor, my win isn't a conviction. It's not a destroyed family. It's not a broken home. It's not a violent community. It's seeing a young person that I did something different than send to jail. I'll put it to you this way. The reason that we have bail is so that you don't flee. It's not a danger thing. We pretend like it's not a danger thing, but we say things like nature and circumstances of the crime, the length of the sentence you might get, all proxies for danger. But in the law, codified in the law in most states, it's about will you return to court? Recognizance is about returning to court. If you don't have $5,000 to get out of jail, where are you going to go? Where are you going to go? I knew so many people that were in jail because they didn't have $500 to put up. Where are you about to go with $500 that I can't find you? Those are prosecutors making those choices. They're making those choices. We need to change the incentive structure. We need to train people differently. We need to get different people in there. We need these seats to be filled so people are as pissed off as I am that the people who this problem impacts the most don't care enough to come in here for a couple hours and just listen to this brother.
I have one question, though. One question, also about the bail. The bail, the bail, for my research, because you have an 8th Amendment right to bail. And I have a question because I mentor a lot of young men, young brothers, and I feel so bad because there's nothing I can tell them as far as their conduct to how to conduct themselves when they're arrested. I tell them, look, you do this, you do that, you cooperate, but in an environment where even when they cooperate and you have the officer who's not de-escalating, he's actually escalating, and if you're saying yes sir, no sir, and you're doing everything, but he's still aggy, as we say, he's still amped up. When he writes a police report, he's not gonna write himself as the villain. He's gonna write, you did this, and he had to do this, even though you were trying to do the right thing. So when the police report is written, and it describes you as being non-cooperative, combative, even though that was his role, when it comes in front of the prosecutor, who has the discretion to either push the charges forward or dismiss the charges, statistically, prosecutors just go with what the officer said. Even though the police report is embellished, has some fabrications in it, and you have a young woman nowadays saying, I didn't do that. And they are not lying, however, that is the problem. What do I say to them? What do I say? You do this, and this one will happen.
Don't change what you're saying.
Yeah,
Don't change what you're saying. That unfortunately is the advice that we have to tell young people. That we even have to have this conversation. Don't change that. Tell your prosecutor that you elect that you want to see the training when it comes to interacting with officers. And I'll give this as a real life example. There came a time, and unfortunately it just didn't happen early enough for me. It took me 6-7 months to figure it out. There came a time where I would get the same, there's a complaint on top of the police report. So you get the complaint with the charges on it, and then the police report behind it supporting the charges. And over a period of time, all young men, all getting the same cases: resisting arrest, disturbing the peace, assault and battery on a police officer. Called it the trifecta. Because every case would involve young men, typically, not doing shit, police coming up on them, having some interaction where they are not trained to de-escalate, they don't have the empathy, and they have serious implicit bias. That conversation doesn't go well because let's be real, it's going both ways, and that's based on our treatment by the police. These young people having to deal with this issue all the time. That doesn't go well. The police put hands on people. And a lot of times you just traumatize young people. So the traumatized young people do what? Even with mentors like you, What are they going to do once it becomes getting their names called at them, getting hands put on them? They react. And that is what every single police report said. I could almost recite it line by line. And you know what I started doing with the trifecta cases when they came in? See ya. Dismiss the case as arraignment. If you want to do, I wouldn't even, a lot of the DAs in my office, because they're good people and they listen to what was going on in the community, they'd ask for some young brothers to do some community service. Not the worst thing in the world, but you know what, like, walking around while you're a young black person is not a crime. And you shouldn't have to interact with police that way. But we have the discretion, and this is what folks don't understand, we have the discretion to do at arraignment. We don't have to deal with bail. See you later, no case. And that's what we're doing with trifecta cases. And you can urge your prosecutor. Next year, 1,000 DA's elections are happening around this country. You can urge your prosecutor and ask him how you're dealing with these cases. What are you doing with these misdemeanor cases with young men interacting with the police in the current climate? What are you doing to resolve the police and community relations? What are you doing? What are you demanding? And if you don't like the answers, vote for the other person.
I want to kick it to Professor Henning, and then we're going to open it up for questions. I see a lot of hands.
Yeah.
But I think related to Rodney's question, right, about youth, Black and Latino youth, talk to us about what happens to them in the juvenile justice system and how their innocence is denied as well.
So you all, I've been listening and my heart is heavy. My heart is heavy for a lot of reasons. One, starting off with Rodney's profound story. I have been doing this, thinking about race and crime and juvenile justice reform for a long time. And I am still, every time I hear stories like this, I am outraged by it. And we cannot become desensitized to it. I start off that way because I want to say something in response to Adam, who I totally respect, and I know where you're coming from when you say that Rodney's story sounds extreme. I got to tell you, it is extreme, but it is not uncommon, okay? It is not uncommon, and I think that if we label it as extreme, then we run the risk of missing what the right solutions are. Rodney's situation, not to speak for your story, Rodney's story happened because of the deep systemic entrenchment of all of these questions of race and crime. It comes from the statutory framework. We're at a Congressional Black Caucus. We need to talk about the statutory framework that allows for this to happen to Rodney. We've been talking about prosecutors. We've got that, elected prosecutors. We've got to talk about the underfunded defense systems, the undertrained defenders. We also have to talk about the criminalization of the black body, period. Why in America that this is okay, which ties directly into what Adam and Shantae and the like have been talking about, the over-policing of young black boys. So I just wanted to start there because I really want us to be careful about calling Rodney's story extreme. So we've had a couple of moments of silence here. I want to have another moment of silence for the beautiful young people who walked in this room. And let me be clear about why I think that why I think it's so critical. So imagine if you close your eyes in a moment of silence and rethink about everything that Rodney just said to you, and think about that if you were 14, if you were 15, if you were 16 years old. So New York has already come up. Every single one of you has heard about Khalif Browder, right? Khalif Browder was in his apartment, pulls out an air conditioner, ties a rope around his neck, and climbs out to hang himself. Why? Because he had been in jail. He had been in jail for over 3 years after extension after extension and continuance after continuance in his case, and then his case was ultimately dismissed. And it was the trauma that he experienced both during his time at Rikers that led to his ultimate suicide. So one of the reasons I got invited to join this panel was to talk about the impact on juveniles, the impact of this bail question on children. And so I want to say from the outset that this bail question impacts children in two different ways. One, the transfer of children, black and brown children, to adult court at the ages of 16. Khalif Browder was charged with a robbery for stealing a backpack from someone. And I am not, stealing is terrible. We're not talking murder. We're not talking anything. We are talking a 16-year-old boy transferred to adult court, sent to adult court after a robbery, okay? And then spending 3 years there. It's unacceptable. Talking about racial disparities, we know that the transfer numbers are absurd. You know, African American boys make up only 16% of the nation's youth between the ages of 10 and 17, yet they account for 53% of children who are tried in adult court. So in terms of reform on all of this, when we think about solutions, we've got to think about systemic statutory solutions. First of all, on the transfer laws. That's like number one. If you want to put a pin in the places where I'll throw out solutions. So there's the transfer question. And knowing that the adult bail statutes are not in any way designed to account for the unique vulnerabilities of adolescents at all. Not at all, right? So there's that. Then you've got, so the second way in which this question of bail impacts children is in juvenile court, and most of us forget that. And I will say, even myself, I've been doing this a long time. I practiced for a long time in a still practice in a jurisdiction that does not impose bail for children. Well, lo and behold, I go out and I do research on this question. There are 19 states that actively impose bail in juvenile courts, okay? Massachusetts, where he's from, okay? So it's critical that we have to, and I've seen a number of reform measures. I mean, I think even
Why is that so messed up? Other than the youth, why is that so messed up?
Why is what?
Imposing bail on children.
I'm gonna keep talking.
Okay.
Trust, Adam, we've been together a long time. I got you, bro. I got you. I got you. I just really want to build to this point because it's really critical, right?
Yeah.
But there are 19 states that impose bail on children, and there are actually 25 states that are silent on the question. And silence is just as bad because then it gives the discretion to the decision makers about whether or not to impose bail or not. So let me get to this critical question. This critical question about why does it matter so much for children. So there's two layers. The first layer is this question of what are the collateral consequences, what are the collateral impacts of imposing bail. A lot of it is the same at the start between juveniles and adults. So first of all, research shows, all of us is good that we've got numbers, you all. We've got data for you. This is what we're trying to say to you, right? That children who are detained pending trial, either because they couldn't afford to pay it or because a judge or a prosecutor made a decision not to release that child, the research shows that children, I'll do this part quickly, are more likely to take a plea or be adjudicated of the present offense. Right? So the offense for which you are presently before the court, you are either more likely to take a plea, which is what we've been talking about, just out of the sheer pressure to get out, or you're more likely to be adjudicated even when you do go to trial, right? Because you're not out with your defense counsel guiding the investigation, things of that nature. Research shows that children who are detained before trial are more likely to receive a harsher sentence on the back end. So if they get found involved or guilty, they get sentenced more harshly. Why? Again, because they haven't been able to be in the community to demonstrate to the fact finder, right, to the sentencer that they can do well. They haven't been able to connect with programs, to get vocational opportunities, to re-enroll in school. Research shows also that there's an impact on recidivism. So this fear that Adam talks about, so I'm afraid they're gonna go out and commit more crime. Guess what? You lock the kid up pending trial, the research shows he's more likely to commit more crimes once he gets out, after having spent some time in jail. Another thing,
My question, and because I don't want to lose that point, for my research, I read McKee versus Pennsylvania, which says that juveniles don't even have right to jury trial. So it's left up to only a judge trial, and in that content.
Absolutely. Right. There are so many challenges, I'm going to use the word nicely, challenges, with juvenile court. And the absence of jury trials is critical, a piece of that. So it's the absence of a higher level of due process for children, right? So you're absolutely right, Rodney. Also, the research shows that the children are, we all know this to be true, are more likely to drop out of school, even from just being detained pending trial, okay? And then there's less opportunity to get a job. Obviously, the very practicality of not being able to get a job, but the employer, even though juvenile records are supposed to be confidential are not, okay? And so ultimately your community finds out and you don't get a job. So those are the basic collateral consequences. I haven't even gotten where Adam knows he wants me to go, which is I know where the adolescent development comes into play. Why is it? There are a number of variables. I don't want to make this the stark contrast too black and white, but I want to say, why did Rodney, how resilient is Rodney? Rodney is sitting here telling us his story. Why is Khalif Browder not here? And what I'm about to say helps us understand, right? The lack, the profound impact of even just a tiny short period of incarceration on a child is huge, right? Children encounter the juvenile justice system and periods of detention at a critical stage in their lives, right? It is a time when either consistent with the research says that children engage in delinquent behavior for a moment, and even if you don't intervene, the vast majority of children will never commit an offense again. You put a child in the juvenile justice system, you expose them to trauma like we just talked about with Rodney, you are setting that child on a life course persistent of crime and self-destruction, okay? Therein lies the problem, all right? And the research shows that even minimal periods of incarceration have a profound, enduring, traumatic impact on children. But we're not talking short time. We're talking years. Khalif Browder, 16, more than 1,000 days in jail, pending trial for a case that was ultimately dismissed, okay? The other things that you need to know about adolescent development, that children who come into the juvenile justice system are already coming into the juvenile justice system with higher levels of mental health disorders, all right? Research shows it. And that that children with disabilities in comparison to children without disabilities are more likely to be detained pre-trial by the judges because they don't understand the behavior. So their behavior of depression, ADHD, learning disabilities, schizophrenia manifest as delinquent behavior as opposed to mental health, right? Or they're choosing to see it. It's a choice, as Adam says. It's a choice, okay? Children who go into detention facilities pending trial are much more vulnerable to physical abuse, right? They have, just their physical stature. The research shows recently 13,000 claims of physical abuse and excessive force, okay? So you've got children who are, like Khalif Browder, if you read his story, subject to beatings both by other youth and by guards while he was in detention. Moreover, Khalif Browder was in solitary confinement for hundreds of days. How do you put a 16-year-old in a black box, okay, and expect them to come out sane? Don't get me started. She
hasn't started yet.
You can't put me on the panel.
She hasn't started.
I'm hot. Also, the research shows, so Khalif Browder is not alone, right? So the research shows approximately 1 in 10, that means 10% of our children, 10% of these people who just walk in the door, okay, have report having thought about suicide, and 11% have actually attempted suicide. That is a tragedy. It is a tragedy. The children who go into detention facilities, higher rates of special education needs, okay, that are not being attended to. I could go on and on and on. What we do know is that children are developmentally different than adults. And this one threw me, I did not know this. So I didn't remember this about Khalif Browder's story, but Khalif Browder's bail was revoked 74 days after he got in, right? And so bail gets revoked for misbehavior, right, inside the facilities. I'm sorry, you're gonna put a 16-year-old in Rikers Island, okay? What do we know about adolescent behavior? I could call on each one of you, could tell me something. How many of you, have a child, know a child, or was a child yourself, okay? That's all you need to know. Immature, more impulsive, less able to exercise self-control, unable to think about the long-term consequences, and then just the sense of outrage, outrage of being in jail when you are protesting your innocence. He never denied his innocence. Over and over again, he kept saying, I am innocent, right? So you're outraged. So you're going to put a 16-year-old in a congregate, I like to call it congregate care, since it is. It's the #1 mental health facility for young people, for young poor people, excuse me. Let's be clear about that.
Yeah.
Young, poor
College
people of
is the
color.
other one.
There we go, right? So you put a 16-year-old in congregate care facility and don't understand why he flips out and gets violations and then gets his bail revoked. So even when he was ready to get out, if he had, which he never did, like he always, maintained his innocence, but had he wanted to post the bail, he could not. So let me just calm down.
No, I was
But
going
let me just say one other thing,
yes.
because you did ask a question
Yes.
about how bail works differently in
His
juvenile
mother
court.
died like 2, maybe 3 weeks later from a broken heart.
Yeah.
Yeah.
I mean, the impacts on
couldn't do
families and
anything for her
communities,
son.
it's
Yeah.
insane. It's insane. I want to make another point that I think folks don't think about when you think about juvenile court, unless you're down there practicing, and this notion of bail. And Tara, you raised this notion about why, or the list of reasons why people are pressured to take pleas. So it's even more complicated for juveniles, right? So you're pleading, you want to plead guilty so you can get out. The immediate rewards. The research shows kids are more interested in the immediate rewards than the long-term gain. So actually Khalif is unusual in his maintaining of his, very unusual in the maintaining of his innocence. But then there are statutes on the books that for juvenile bail statutes. Most of them are equivalent or virtually identical to the adult statutes. But there are a handful of them that provide a list of factors that the judge will consider in deciding whether or not to impose bail and how much to impose bail. And one of those considerations is assessing the parent's ability to pay. Okay, you know where I'm going with this? So the problem is, there's a problem across the juvenile justice system with making any decisions, fines, fees, bail determinations, based on the parent's ability to pay. Because one, parents are just poorly equipped, right? First of all, let's just, they can't afford it, right? Because they're being forced to choose between getting one child out of jail and feeding everybody else in the family, all right? So there's that choice that you have to make. Then my experience, this is somewhat shocking to many people in the room, probably to many people in the room, is that parents are really poor decision makers in this context, in the juvenile justice context. Yeah. That's right, because they're at their wits' end. They've got this child who is acting out. They haven't figured out, they don't understand. They haven't figured out how to get help, and so they too think that the juvenile justice system is a way to get help for their kids. And so then,
The number of mothers that ask me to hold their kids, ask for bail.
Absolutely. And so they're really poor decision makers. So what they'll say is, well, I'm not going to pay the bail so that he can learn his lesson. Not understanding, what did I just say in the research, even a tiny window of incarceration for a child of that age has a profound and traumatic lifelong impact. And they don't realize that. And they also don't realize that the system won't give them the help that they think they're going to get, right? So then you've got kids being pressured because they want to get out. They're pressured by their families to get out. And then they're pressured by adults. So this whole notion of vulnerability, again, Khalif Browder is unusual, right? You've got kids who plead guilty. Why not? Because I've already confessed to the police because the police coerced me, during the statement, during the interrogation process, okay? So it's really, really complicated for juveniles. I will stop.
Thank you so much. As you can see, as you can see, all of our panelists are very, very passionate about this issue because it is at the core. I think Adam said it so beautifully. It's just the core of what's happening in our country, and everybody should really be in this room hearing this conversation. But I do want to give folks some tools, and so I'm going to go to one of the questions we got online before the panel, and then as folks if you've written down questions, we'll just ask you to, we'll take those up so that we can take some of the questions from the audience. But Mahalia asked online, in terms of solutions, what can be done to address the long, lengthy waiting time spend in jail before a case comes up for trial, and she referenced Khalif as an example of someone who sat for so long. I don't know if any of our panelists have any thoughts on that.
Number one, the statutory reform,
Right.
right? So it's twofold. It's the statutory reform to have meaningful, one, to have a speedy trial on the books. But then secondly, particularly in a place like New York, having speedy trial means something,
Right.
all right? And so for lawyers in the room, most of these people think about speedy trial under the Constitution is, you have to come to trial within a year. No. I'm talking about the statutory parameters. And for children, it should be very, very short. 45 to 60 days, and it must be enforced. So what happens in a place like New York, and I don't practice there, people who do practice there, please let me know. As it has been explained to me, that people in New York meet the statutory guideline. Let's say I don't know what the number is. Let's say if it's 45 days or 60 days. So long as the case gets called on the docket within the 60 days, it's okay. It meets the statutory speedy trial parameters, but you can continue and continue and continue. And so therefore, it's not meaningful. So it's got to be both statutory reform and it's got to be enforced with meaning.
Yeah, and as it relates to New York, when practicing there, even if, as a defendant, you come to court and your attorney is there, if the delay is because the court is too clogged up and there's too many cases, they don't have a place for you to take the trial, or if the prosecutor is not ready, that time just gets added on and gets added on. So yeah, I think that's right in terms of having a statutory framework, but also having one that is short and that's enforced.
Which is terrible in and of itself, but think about that, right? Like, I saw kids come to court for 30 seconds in a courtroom and they're just getting a new court date. Nothing happening. Evidence wasn't there, defense attorney wasn't there, prosecutors are just, there are a million reasons. That's a mom who had to make arrangements in the morning to take care of the kids, get them on the bus, whatever. That's a mother taking a day out of work. That's a father missing a day of work. That's a day out of school every single day for these kids, because in a lot of the places that this impacts us, kids aren't allowed to come to school if they're going to be late. Just think about the collateral consequences of all this, just not the impact on that individual person. It destroys communities.
Yeah. And this is a question for you, Adam. Why are prosecutors so indignant even in the face of truth despite evidence of innocence?
Great question.
If you can speak for all prosecutors.
I can't.
But you did talk about this fear. If you can maybe expound a little bit on that, especially when we look at
I'll call it what it is. It's implicit bias. Okay.
Mm-hmm.
There are many studies, and
can you explain to the audience kind of what that is?
I will.
Yeah.
Again, I don't want people walking away thinking, God, there are all these bad people lurking out here. How are we going to fix this problem? This is something that has to do with conditioning. Okay. Think about first of all, does anybody think it's messed up that young kids have to come and listen to a discussion about the incarceration of our people? That is troubling to me. I've never seen white kids at a conference have to go listen about how their folks are locked up. Implicit bias is not what we see in Charlottesville and in the civil rights movement and all those pictures. Implicit bias is what we deal with every day with people who are just conditioned to feel some way. And truth be told, it happens to everyone in here too. It is a natural reaction as human beings. We learn from life experience, and when that life experience is drawn from places where the information you're receiving is already biased, that goes in your head and that's how you learn. So if I'm a prosecutor and I've never interacted with a person of color, and I hear this young person has a gun and he's a black person, I don't think to myself, well, that kid lives in a community that's surrounded by violence. He's seen guns since he was a little kid. His father had a gun. We're not thinking about those things. We're thinking, I saw Boys in the Hood. I heard Jay-Z's new album. We make all these connections. And so the idea that somebody that we've learned is typically guilty. Think about the movies or television shows where you see the black person who was guilty of the crime. Never see it. And so I've been conditioned to see that person as guilty first. And this is not me spouting about my experience. This is actual doctors going out and doing this stuff. Every doctor that works with children would tell you don't do this stuff. Every doctor that would tell you implicit bias is a real thing would tell you that prosecutors should not be coming from the places where they come from. And if they are going to continue to do so, then I didn't need to learn wills and trusts in estates in law school. I didn't need to learn about torts. What I needed to learn was about implicit bias, about poverty, about the race history of the United States of America, about what police are actually doing. And then I should be able to go out and maybe exercise my power.
Yeah, so I think in terms of solutions, right, like training for prosecutors, well, first electing prosecutors who are more progressive, who are willing to give training to their line prosecutors to really attack implicit bias. Yeah, Rodney?
I wanted to add a feature to that
We'll do
question.
Rodney and we'll come to you.
Okay.
I'm a prosecutor in South Florida, and I found what works for me is when I get the probable cause reports on my desk, it's best to call the police officers then and ask them, okay, what actually happened?
Yep.
Did it happen this way? That way you get an idea of what really happened. I think that's the best thing that you can do. I mean, we do get a lot of cases, and I can see how easy it is for everyone who is not a part of certain neighborhoods or haven't had the same background as I have in the office to have that implicit bias, but it takes more of us who don't have it to be more proactive and to go the extra mile and say, okay, officer, why did you pull this person over? Was the taillight really broken?
Yeah.
Just a follow-up.
Yeah. Thank you, Rodney, yeah.
I don't know.
And then
I
to
wanted answer
Professor
my
Henning.
question. She probably more or less answered, but I want to add another feature to it. And we talk about implicit bias, which is 100%. But in those cases where an individual or a prosecutor has exculpatory evidence, which is for evidence in a person's behalf, and they still withhold it for whatever particular reason. They know it exists, know it is down the line it's going to be a Brady violation, but they still maintain this position that I'm not going to provide his attorney with this evidence that can help his client. And that's something that has to be addressed within the prosecutor office as well, because that's systemic too. Because each year, according to the University of Michigan, the number of people who are exonerated from being falsely convicted grows.
Yep.
Because of prosecutors withholding exculpatory evidence or some particular form of what evidence, or not vetting the eyewitness accordingly. So in that regard, what can the prosecutor office do to rein that in?
First of all, just like you got to be checking and firing people, but the issue again is like you're taking young people, putting them in this environment, and saying, win trials, win trials. That's how you get ahead in this office. If you win, you want to be a homicide prosecutor, you got to go to trial, and you got to win. And so when you are playing a game, and the game is grimy, and it's about your bottom dollar, it's about you making it ahead, you can be persuaded to maybe look the other way. People who are hiding evidence, people who are lying, people who are doing things that they know not to be true, and it affects innocent people. Like I said, there's a special place in hell for that person. Like that is a disrespect to everybody up here. It's a disrespect to the profession. Those people exist. Those people are doing because they might be racist. My experience, though, is that when people are doing something wrong in the prosecutor's office, it's about motivations that have to do with what happens to me. And that's another place that we fail in our training and our education of prosecutors. When every piece of paper about Rodney said State of New Jersey versus Rodney, as if somehow, because Rodney committed a crime, despite the fact that 99% of the time he's going to come back out, Rodney was no longer part of the state. Nobody ever introduced me to the concept that most of the people I interacted with in the criminal justice system were not going to go to jail. If they went for a very short period of time, and if they went for a long time, ultimately they're going to come back to the same community. If I'm representing this community, then how do we have this versus that? That is an issue that we can easily take care of by just taking the people who are in law school who want to be prosecutors and saying, this is how we do it.
And it's also how we define safety, right?
Yep, success and safety.
Success and safety, because we define police officers are measured by how many arrests they make. Like that becomes a measure of whether they're doing a good job as a police officer. For the prosecutor, how many convictions they get becomes a measure of how well they're doing as a prosecutor. For the Department of Corrections, the measure of their success becomes whether or not that person leaves there and commits another crime, regardless of whether the person ever gets a job, ever rebuilds his or her life, ever becomes a contributing member of the society. As long as they can be totally homeless, as long as they're not getting arrested and committing more crimes.
Yep.
The Department of Corrections has done its job because they're not doing it. So we have to totally redefine safety because, and when I say we, I mean all of us
Yes.
have to redefine safety because, you know, I wanted to pull this out. 95% of elected prosecutors are white. 14 states have no elected prosecutors of color at all, and just 1% of elected prosecutors are minority women. And when you are in a jurisdiction that elects their prosecutor,
I'm going to beat a dead horse on this, which is going back to systemic reform. I think it's great. We have to have individual stakeholders at the table to have these conversations about implicit racial bias, et cetera. But we also have to talk about public perception and systemic reform,
Yes.
or we're going to get nowhere.
Yes.
And so we start off having this conversation about implicit racial bias. It's not just prosecutors. It's all of the stakeholders. But let me say this. This is what is surprising to learn. There are empirical studies on implicit racial bias that focus on policymakers, right? So there's a wonderful study out in which the participants, both public and just citizens and policymakers, were asked to determine whether or not they approved of a piece of legislation that would result in the transfer of children to adult court. And the way they ran the study was some of the participants were primed with a black face before they were given a fact pattern to read, and then asked the question, do you support this proposed legislation? Other people were primed with a white face, right? And you know exactly how that study came out. The folks who were primed with a black face were more likely to favor transfer of juveniles to adult court. So it's all the way back to the public perception, and then to the policymakers. So I mean, I think I just really worry about us talking about these reform in sort of this piecemeal way. It is absolutely true. We've got to do implicit racial bias training. I do implicit racial. He does them for prosecutors. I actually do them for prosecutors and defense attorneys, right? Because Rodney got into his situation in large part because you've got 3 different public defenders who are well-intentioned. And in fact, it is folks like public defenders and the liberals who are, there's this thing called bias blind spot. Anybody heard that? It's this idea that I think that everyone else is biased and not me. Well, guess what? That makes you more vulnerable to acting subconsciously on your biases because you're not even owning it, right?
So important.
So you've got to, it's throughout the entire system. So the last thing I'll say as it relates to that is this notion, it is powerful and important that there are so few black prosecutors. Absolutely. Black prosecutors doesn't do the job, right? We know this is true. I live in a jurisdiction, where in the District of Columbia, where
The DA.
I mean, like literally everyone, here. Okay, I'm exaggerating. In the criminal justice system, the folks in power are people of color. They're black people. They didn't just have color. They're black people, and we still have the same statistical disparity. So why is that? So when it comes to criminal justice issue, okay, the research shows that the correlation between black and crime is so deeply embedded in all of our psyche. All of our psyche.
All of
that
us.
we cannot get ourselves out of this, right? So it is really deeply entrenched in systems. And so it just worries me to spend so much time talking about prosecutors. We have to, okay? I think it's important. We've got to talk systemic reform.
Could I ask a question? Hey, good evening. My name is Tyler Brown. I'm an executive director for an organization called Run Hope Work. We get young folks that come home from the justice system, and our goal is to make sure they don't go back. So we train them in vocational trades and construction trades. We do mental health and training through mindfulness. So we get them in a meditation circle. And then we also do personal fitness training. Once they're done with us, we get into an apprenticeship, try to manage them. One of the most difficult things we find is that the trauma they endure while they're incarcerated follows them out. The destabilization and the dislocation from family and all these things make it hard for them to sustain gainful employment once they get it. So my two questions are, number one, I think Michelle Alexander laid out a great treatise on the war on drugs effect on the system, how we got to a system that's looking at people as bodies to be housed rather than actually trying to serve justice, right? So could you guys speak to war on drugs really quickly? And then my second point is, what do us in civil society do? What are the fundamental points that we can do to make change besides organizing voter drives against prosecutors? Because the reality of getting a low-income community to organize and go to the polls and fight in a small election for a prosecutor, that they don't really understand the impact. I mean, the reality is black folks understand presidential elections, mayoral races, and that's about it.
Yep.
We don't vote in council elections. We don't vote for civil servants. So the reality is our communities aren't quite going to engage in that solution effectively in the next 10 years. But what can we do fundamentally as civil society besides just marching? Because it seems marching exasperates the issue and gives the prosecutor with bad intentions more fuel for their fire. Lastly, please just speak to the association between police unions, prosecutors, and the fact that behind closed doors, it's an old boys network. As much as the prosecutors that have power, they're friends with the police chief. They go drink at the same bar. Let's be real, like you said, it's on the same team. So electing a prosecutor won't do it, but what can we do as civil society?
I want to take the. I want to take the first question, but to prove your point that you just made about our community and voting, the primary election for district attorney in Brooklyn happened the other day. Lots and lots of candidates. One of the biggest elections that's going to happen in the city of New York until 2018. And certainly the biggest election that affects us. Out of 4 million eligible voters for the primary that is going to decide the general, because they're all Democrats, out of 4 million eligible voters, 100,000 showed up. And for my money, the right guy won, but that's the example that you're drawing is just like, we didn't come out. We didn't come out and make a statement like we're not going to do this anymore. The first question? War on drugs. War on drugs. War on drugs got us to where we were, all right? Like, war on drugs is definitely a driver of mass incarceration. I don't talk about the war on drugs because I think it gives the police a pass because they can say, we're not prosecuting marijuana anymore. We have drug court, all right? And two, especially in this climate that we have today, it's done something else. The juvenile justice system has seen a massive decline in incarceration. Not to say that there's still not lots and lots of kids in jail. Massive decline in kids in jail. Do you know what's gone way up as that's going down? Racial disparity. Because when we're taking out the low-level, non-violent drug offenders, guess who we're taking out? And who are we putting in? The violent criminals. So we need to start talking about what violence is in conjunction with what safety is, what violence is, where it comes from, and what we can do about it, and understand that prison begets violence. You get more violence from putting someone in prison. So the war on drugs, cool, got it. Definitely informative of the conversation, but I don't want to leave it at that. I want to make sure that if we are vested in this problem, talking about violence, inner city violence, if that's what you want to call it, black on black violence, if that's what you want to call it, we need to have a conversation about that. And especially when it does come to election times, ask the prosecutors what they're doing about it. Because if they tell you that their answer is swift and severe, sending a message to the community, then they have a fundamental misunderstanding of what our safety looks like.
I assume that's the message. I mean, they don't need to tell me. That's the message. That's what gets them elected. Tough on crime. Republicans are running with right? We got a guy in office tough on crime. In fact, Jeff Sessions is tough on crime. It's mandated from the Justice Department down. I don't think the guy that runs weak on crime wins the prosecution.
You are correct on that. You're correct on that.
So what do we do outside of prosecution?
Don't give up on that yet. Hold on. 25 election. It hasn't. Ever in the history.
So as civil society, we can make the change. The elected leaders are not the ones that can do it.
2016, there are 25. So Tara talked about elections, right? 95% of prosecutors are white, elected prosecutors. 95% of prosecutors are incumbents. They win their elections, okay? 85% run unopposed, all right? Those, so
Say
let's,
that last part again.
85% run unopposed, people, lawyers in this room. 85% run unopposed. 95% win those elections. 2016, there were 25 elections around the country, and 5 of them happened in major cities. 14 went to non-incumbents. 5 of them went to progressive major city prosecutors. 3 of them went to black women. 2017, Pennsylvania had a smattering of elections, one in Philadelphia, which we represent a monster part of the population, including the juvenile justice system. The election went to who? A tough on crime person? Nope. The Bernie Sanders of prosecutors who said, I will never try a kid as an adult. And so here's where I hear you. It's never happened. This is where it stops. Because in 2018, every DA with the exception of a few in California, every DA with the exception of a few in New York, every DA with the exception of a few in Florida, Ohio, Massachusetts, are all up for election. And so if we get our shit together before 2018, we empower our people who we know that are lawyers, who care about these issues, get them to run it, and then we come out and vote, 2018, we could change the game.
And so can I want to just kind of come in?
There's another component to that as well, because I have the Rodney Roberts Foundation, and what we do, and a big part of what we do is we have a law library also, a community law library, because one of the factors that we think is a problem is that parents, families are so unaware of what to do. They're not informed, they're not educated, so they're left in the dark in how to address certain problems, even when it comes to dealing with an attorney, dealing with a prosecutor, dealing with law enforcement. So we try to empower the families. Like we have, like the majority of the people who utilize our facility or what we are mothers or who have children, and they want to educate themselves in law, in jurisprudence, in community politics, to be able to teach their children more than just what they're seeing on TV. So I think that, and I strive to make sure that the community is properly educated and what they are capable and what their strengths are, as opposed to just waiting for someone to be appointed to be their champion, where they become the champion. So
I'll take the question here. And yes.
Okay. So I have a question, but I wanted to quick 30-second comment on. I'm so glad you brought up the Pennsylvania campaign. I work for the ACLU, and we worked on that Pennsylvania campaign.
Can you also talk about Meet Your DA?
Sorry?
The Meet Your DA campaign with the ACLU?
Yes, with California. But I wanted to tell you about quickly on the Pennsylvania. There were 50 formerly incarcerated men and women who knocked on more than 11,000 doors, and that voter turnout, the way they had that result in the Philadelphia campaign, that was the largest turnout for a DA race since 2001. So I don't want anyone to walk out of this room thinking that this is not possible and that people are not doing it right now, and then we cannot continue to spread that across the country.
And
so sorry, I just wanted to share that.
I just wanted, because the comment was made earlier about the power of social media. Like, if you're figuring out how, all of you hit exactly where I was going, this whole notion of community education. Folks don't go out and vote because they have no idea what the issues are, when the races come up, what's at stake, and if we were making us think. So I think it's an intentional partnership from between the folks who are running, right? And even small organizations that can get the word out and doing door to door. It can be done.
Mm-hmm. She has a question. Did you have a question? She made a comment, but did you also have a question?
It would take up too much time. And I can answer any questions about California after this as well. So my question was really to all of you, but especially to you, Adam. We do state-based legislative work, and a lot of folks are asking about how do we get more transparency, accountability for prosecutors. And of course, although their job is to enforce the law, in many state legislatures, we're seeing them also shape what the law says about how that affects them. So what advice do you have on dealing with DA's associations as they go and try to kill efforts to bring accountability and oversight to the work?
Yep.
That's a good question. Thank you.
Stop calling it accountability and oversight. It's a branding issue, right? So as this wave comes of like what you did in Philadelphia, We can do it anywhere. And as that happens, Larry Krasner scares the shit out of tough DAs because they see the writing on the wall. We need to do something other than talk about trials and convictions. And so when you talk about transparency and accountability, people back up. You talk about, but we can show people with data what metrics you're achieving that are good. How many people coming through your prosecutor's office are more educated on the back end of the prosecution? How many more involved in pro-social activities? In the juvenile unit that I was running, I didn't care how many kids we locked up. I cared how many kids, especially black men, walked across the graduation stage. That's how you made it in the juvenile unit. And so what I do now, and I'm not trying to trick anybody, this is actually a benefit to you. What I do now is say, I don't want to talk to you about, well, I don't want to talk to you about transparency and accountability. I want to talk to you about better incentives so that when that election comes around and your opponent is talking about the tough on crime cases, be like, cool, but look at this graph with all of this data on it. And that is public record that you'll be able to access for your transparency and accountability. It's branding, and your generation knows more about that than anybody.
I wanted to say something because I'm part of an organization called It Can Happen to You, which is a Albany-based organization that fights for legislation to be created for oversight committee to be developed in New York. I travel back and forth to Albany with this organization. We meet with senators, councilmen and women on large part. The bill had very good progress the first year. We had great bipartisan support for the bill. Our bill was going to be a tier level that, based on the prosecutorial egregious behavior or misconduct, there would be certain levels of sanctions. The first year, the bill made it all the way past and made it to the Senate floor. It got stalled out because it came behind the rent control bill. So you know that, New York. So we came back the next year to we submitted a bill to fight for oversight because we feel everyone has oversight. Even judges have judicial oversight. The Bar Association has a very limited scale of oversight for prosecutors, but it's not enough. So when we came back the next year, our assembly, our team, we could not believe the amount of prosecutors who were waiting for us there. First year, they wasn't maybe aware that we were doing this, but when they got wind that we were coming and asking for oversight to be created for their office, it came with a delegate, a team, and they swept through that Senate. By the time we got there, nobody wanted to really hear what we had to say because they had laid the groundwork, so we didn't get the same support we got the first year because they had came and shut it down, basically. So oversight is a fair word to me and to a lot of people that a lot of prosecutor officers really don't want to hear at this point because it will mean a monitoring system that probably impose a penalty on them for some of their behavior, which they don't have now.
So I don't think we have any more time. I really appreciate your interest and your questions and this discussion. I hope it gave you something to think about, some solutions and some strategies. I just want to leave you with this quote. I was listening to On Being this morning, and Junot Diaz, he's a writer, and he said something that really stuck with me, and I always like to leave a room with some hope and some fire. And what he said was, we have broken every chain this society has tried to throw around our necks. They don't stop trying, we will break them again. And so go out and break these chains in your communities.
Before
everybody
jumps out, calls to action. If you want to know how to do this stuff, ACLU is running a huge campaign called Meet Your DA in preparation for the 2018 election. Colorsofchange.org is an organization that is running a similar type of platform, how to learn about your DA and what to do about it. Measures for Justice is an online platform that you can use to look at data in different places. Prosecutor Impact is my organization training DAs. I'd love to hear from people what they would want their DAs to know. Please, 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 if you're asking what you can do as a civic community, understand that this is the most important thing that's going to happen.
And I would just plug also, Innocence Project has a website called The Guilty Plea Problem. Check that out. It has information about guilty pleas, why they happen, and solutions to how we can stop it. Thank you guys so much.